Good morning to all of you. Myself, Dr. Harpreet Kaur from Khalsa College of Law, Amritsar, going to speak on the topic titled as Justiciability of Fundamental Rights under Article 13. Article 13 provides teeth to fundamental rights. It provides concept of justiciability of fundamental right, which means on the violation of fundamental rights, individual can approach to the court. All laws, either pre-constitutional laws or post-constitutional laws, if they contravene with fundamental rights of an individual, that can be called as a void laws at the extent of inconsistency. Article 13 provides concept of judicial review. It is also said to be Charter of Judicial Review. The power of judicial review on legislative action is the integral and essential part constituting basic structure of the Constitution. All laws in the force of territory of India before the commencement of Constitution, if they contravene with fundamental right of an individual, that can be called as a void at the extent of inconsistency. Article 13 clause 2 says that state shall not make any law which abridges or violates the right of an individual. That law would be called as a void at the extent of inconsistency. All in determining that valid laws can be separated from invalid laws by certain provisions. First of all, we have to see the intention of the legislature. We have to see the historical background, object, scope, and context in which that legislation has been made. All the valid laws can be separated from invalid laws by if that law can be separated from each other. That means that valid portion can be separated from valid portion. The scheme of the law is not disturbed. The meaning is not disturbed. In that case, that law would be called as a valid law. But if that provision is inextricably mixed up in such a manner that cannot be separated from one another, in that case, the whole law would be called as a void. Doctrine of eclipse and post-constitutional laws. In case of Keshava Madhva Menon case versus State of Union of India, in that case, Supreme Court held that all post-constitutional laws, if they contravene with fundamental right of an individual, that would be called as a void at the extent of inconsistency, but that law would not be called as a void in toto, in all purposes, all times, and for all persons. That means that law would be called as a invalid for that particular person whose right it has violated. Doctrine of eclipse and 31B read with 9th schedule. 31B titled as validation of rules and regulations. Article 31B says that if any law get the protection of 9th schedule, that either it has violated the fundamental right of individual, still that law cannot be called as a void law. That law would get the protection of the 9th schedule. Doctrine of a waiver. Doctrine of waiver says that all the rights and privileges of individual cannot be waived, because Supreme Court held that it is not the sweet will of an individual that he want to waive his fundamental right. But Supreme Court held that in no case fundamental right cannot be waived. Article 13 clause 3 says that all laws, that regulations, rules, bylaws, usage, and custom all in the territory of India has the force of law, which means that object of this provision is that fundamental right should not be violated by not only by the state action, state legislature or executive, but also not by the instrumentalities and agencies of the government. All the personal laws, Hindu law, Muslim law, all are not covered under the term of law under Article 13. Article 13 under Article 13 does not cover Article 368. We have to keep in mind a few points. First, we will discuss two cases. First one is Shankari Prasad versus State of UP, a State of Union of India. In that case, Supreme Court held that Article 13 has ordinary legislative power, whereas power of 368 is a constituent power. So that is why Article 13 does not cover amendment of Constitution under Article 368. This case was overruled by other case, that is Golaknath versus Union of India. In this case, court has held that Article 13 does not cover Article 368. This case leads to one amendment, that is a 24th Amendment 1971. In this amendment, clause 4 in Article 13 and clause 3 in Article 368 was added. 360 the provision of this article says that Article 13 does not cover Article 368 titled as Amendment of Constitution. This amendment leads to one case which was upheld by the Supreme Court. That case is Keshavanand Bharati versus State of Kerala. Supreme Court held that Article 13 excludes amendment of Constitution under Article 13. Thank you.